The other thing, and I think that again, this goes back to kind of this overarching goal of compliance under the open meeting law. If you make a mistake under the open meeting law, there's a mechanism built into the law that enables you to fix your mistake. And I think that that's really important. As the Attorney General said at the beginning of his piece, you know, government is a trusteeship. Well, part of that trusteeship is that in Idaho in particular, we don't have professional county commissioners or professional city councilors. Everyone is a volunteer. They come from all walks of life. It's unreasonable as an expectation that you show up for the job and you're an expert on all these laws. So if the goal is compliance, you have to have mechanisms built in to encourage compliance. One of those mechanisms is the cure provision, which enables a body to recognize, hey, we made a mistake, we want to fix it. And it sets out how you do it. When you're contemplating whether or not you should fix a mistake, I can't tell you the answer to that question, but I will give you two scenarios for you to contemplate. Scenario number one, you heard a little bit about briefly. The Idaho Land Board went up to Coeur d'Alene. They failed to properly notice their meeting. What the Attorney General didn't tell you was that once he realized that, he called me up and said, what do we do? And I said, don't worry, I've got a fake passport and a ticket to Mexico. He did not take that advice. I don't know why. I thought it was great. I thought it was sound at the time. But what I discussed with the Attorney General was, let's fix the mistake. Just say, look, we made a mistake. Declare everything, any action that you took at the meeting as null and void, and then reschedule the meeting, notice it properly, and start the whole thing over. As he said, the only coverage you saw of that open meeting law violation, which is what it was a little blurb in Betsy's blog. And I mean, little. We're talking small paragraph little. So that's scenario one.
You keep on, it won't be next time.
That's right. She's already working on larger fonts and bold.
Actually, we are.
But that was, and I present that to you as scenario one. Scenario two, we received an open meeting law complaint, and it was from a county, and the county said, we'd like you to investigate this, and we said, we will. So we looked into it, we called up the county, and we said, hey, we think you violated the open meeting law. If you say you made a mistake, we'll do some training. End of story. The response we got from them was, we didn't violate the open meeting law. And so we went back and we had a meeting and we called them up and we said, hey, we think you violated the open meeting law. We're going to file a complaint. Do you want to resolve this? They said, no, we didn't violate the open meeting law. So we filed the complaint. Guess what happens the day we file the open meeting law complaint in court? Boom, it hits the press. And it's not little blurbs, it's top of the fold, big headlines. Commission violates open meeting, Attorney General alleges commission violates open meeting law. I don't care where you're at, that's not a good headline. So we go to court and the judge says you violated the open meeting law. What do you think the county did at that point?
No, we didn't.
No, we didn't. We're going to appeal it. So the judge rules. Judge rules county violates open meeting law. Boom, all across the press. We go up on appeal. The Supreme Court says you violated the open meeting law. The headline writes itself. Supreme Court says county violated the open meeting law. Now think about this in the context of about a year and a half as it works its way through the court and how many times the media gets to tee off on that county commission. And so I won't make the decision for you, but I present to you scenario one and I present to you scenario two.
And a fun advantage of scenario two is then the media also gets to write the story afterwards, tallying up how much in taxpayer funds was spent on this fruitless defense.
Ron, if I may, the law says violating a person shall be subject to a $50 fine. I'm assuming that Mr. Wasden didn't pay $50 for their mistake that they made.
No, it's because
when would he have had to if he had?
So in the way that fine works, is the cure provision allows you to avoid the fine, because essentially what you're saying is, we messed up, we're gonna do it again. And so by taking that step in curing the violation,
There is no
there is no fine.
fine.
Now, if you violate it every month and cure it every month, now we've got an issue, because it's a repeat violation. But the fact that that happened once and they cured it, there was no fine. In the other instance, the fine is levied when the court says you violated the open meeting law. Or, for example, if we were to investigate it, we could have a settlement where folks say, yeah, we'll pay a fine and have some training. Usually when our office gets involved, if we think that somebody violated the open meeting law, we want to give them the chance to say, we messed up, we want to have training on the open meeting law, and again, kind of get everybody working in that compliance direction. But once the court orders the fine, you're kind of stuck at that point. Yes, ma'am?
I have a question about serial meeting.
Mhm.
And
We like cereal.
there was a time in the past where one member of a board would contact Chris, and then Ivor, and then Nancy, and then me about the same topic. And there was some discussion about, was that a serial meeting by effect of contacting those individuals?
Yes.
Okay.
And serial meeting, that's a really good question. Serial meetings, you can't, what you do is you actually create a quorum by those contacts. It's like a game of telephone.
Okay.
One of the most challenging parts of compliance with the open meeting law is email. And email, because of a single button, reply all. And so I have been on boards where a staff member appropriately sends out information to the board. All it takes is for one board member to hit reply all and say, oh, I don't think we should talk about this because I still want to hear from so-and-so, and I don't know that this is what we should be doing anyway. You've just triggered a potential open meeting law violation. Now, recognizing that we're all human and that that may happen, how do we fix it? To me, the best thing you can do is hit print. And then at the start of your next meeting, say, this is what happened. I have copies for everybody in the office, or in the audience. I want to make sure that you know that we made a mistake. Everybody can see what we were doing and get the deliberation into the record that way. That's the way that you clean up that scenario. But you do have to be very careful. The other thing is if you've got commissioners that kind of hang out and stop by offices and go office to office. That's another way that you trigger kind of that serial, we're creating a quorum by going down the pathway and talking to one another. So you want to be really careful of those sorts of things. When you have information that's disseminated by staff members, to me, the smartest way to handle that is any other information goes back to whoever the staff member that distributed it, not to any other board members. And that way, if it becomes something that needs to get into the record, you have the ability to do that without violating the open meeting law.
And you really want to be careful if you have a cereal meeting with General Mills.
So one of the other things that's important is that if somebody does file an open meeting complaint against you, against your board, while you're going through the cure process, that complaint is stayed, because if you cure it, that can actually be a basis for dismissal of the underlying complaint within the court proceeding. And so the cure gives you a real opportunity to correct a mistake under the open meeting law. And believe it or not, Bill Thompson was instrumental in putting that cure provision together back in '09. We did quite a bit of work together on that as we built it. So if you have any of the bad stuff that you want to complain about was probably my fault. Any of the brilliant stuff was Bill's idea.
You're so gracious.
In order to help folks kind of navigate the cure process within the open meeting handbook, we have a chart for how you work through that. We also have included a number of checklists for regular meetings, special meetings, executive sessions that you can go through and make sure, have we done all of the steps that are required? The land board uses these checklists on a regular basis. Before just about every meeting, the Attorney General pulls out the checklist to make sure that it's been complied with. Why does he do that? because we had a scenario where it wasn't done. So an ounce of prevention is worth a pound of cure, right? And then there's a form for going into an executive session, and then a form and a motion in order to amend the agenda. And so essentially what we've done is we've tried to create a package that wherever you're at within the process, you've at least got something that you can refer to say, where do I start? With that, I'm happy to answer any questions. Yes?
I had a situation when I worked at a different county. When you're in executive session with the board, and for example, say there's a situation going on with the city, and you work at the county, and the city attorney and the deputy prosecutor are exchanging agreements, trying to come to a settlement, and there's potential litigation, and the information is attorney-client privilege, so we're meeting in executive session to discuss it. And the board gives the attorney direction on how they would like to go. They're not making a final decision. Any final decision will be made in open session, but practically, they're giving the attorney direction on how to proceed, how they want to proceed. And then, does the board have to go out of executive session to give their attorney direction on what to do? Because then I had another attorney that worked for the city claiming that the board was violating Open Meetings Act every time we came out with a new draft of a document, saying, well, you never talked about that. When did you make that decision to make that change in the draft?
Yeah, so the answer to your question, I'm going to start with an answer only a lawyer can love, is it depends. And I look at it as, for general direction, you probably don't need to come back into open session. Like, you wouldn't come into open session and say, we approve a settlement range of $50,000 to $100,000, because that defeats the whole purpose of it. And so when you're getting that sort of thing, the fact that they say, you go in, you discuss the case that's already been filed, so you're under the right provision, and you're saying, I think we can settle this somewhere between 50 and 100, and everybody's going, yeah, that sounds about right. That's good, because the final number is going to have to be approved by the board in an open session. And so you're still, you have that backstop where the final settlement is going to be approved by the board. Similarly, if you're negotiating an agreement, and there's positions that you need to take as you negotiate out that agreement, which always happens. If you come out of the executive session and you say, I approve the changes that we made to paragraph 2, 3, and 7, but we're still discussing paragraphs 9, 11, and 18, that may undermine your entire negotiating position based on whatever it is that's in those paragraphs. And so the fact that you're getting that general direction of, look, we're okay, kind of, but we want you to do more work in these areas, again, the final agreement is going to be put in front of the board for approval, and that will be done in an open session.
And I guess looking back, it went even further than that. If the board told the operations director to follow up with this person, this attorney was trying to say that every single decision of what the board wanted to do in this whole long process had to be on the open record. And
Yeah.
it wasn't like a major decision. It was like little things that have to be done to accomplish the end goal.
Right, and part of that is the open meeting law does not apply to administrative or ministerial decisions. And so, for example, if you make the big decision that we're going to paint the barn red, you don't necessarily have to have an open meeting to determine whether or not you buy Glidden or
Right.
Dutch Boy. The fact that you've got red paint and they've said this is how much you can spend, now they become what I would call administrative or ministerial decisions. And I think that's kind of what you're running into is we have the big decision of the agreement, but now we've got a lot of little ministerial, administrative decisions of the nuts and bolts within that. And that's the way that I would parse that out.
That makes sense. So on a related note, I get direction from the board on how to proceed. I'm in my office drafting. I have emails with the city attorney going back and forth. We're discussing. And now I need to run something by the board. Do I have to wait 24 hours to have it on executive session to run it by? Can I go over to the commissioner's office and talk to two of them and say, because again, I'm still working on a draft document or
Right.
something.
And
Get
I think,
permission
again,
from
it
two
comes back
commissioners.
to, I think you apply the same analysis. Are we dealing with big decision or with ministerial administrative types of decisions? And the answer to those two questions, or that one question, is going to determine whether or not you do have to wait and get it onto an agenda, or whether you can kind of get consensus.
Talk to Bill, that's the best answer.
Do whatever he says.
Thank you.
Sure, other questions?
You're brilliant, Brahman, you're brilliant.
One thing I forgot to mention, and hopefully this doesn't spawn a bunch of questions. We get asked the question all the time, who is allowed to be in executive session? The answer to that question is the board decides who gets to be in executive session. And so if the board says I want X, Y, and Z in executive session, that's who gets to come in. With that being said, I again return to my cautionary note about Ben Franklin and secrets. If you have too many people in the executive session, what's the point of it? And so always come at it from that perspective. All right, Betsy?
But you can take information, right, in
Oh, yeah.
executive session.
Sure.
Just one quick thing before we go to the break about the Idaho legislature and executive sessions. In your open meeting law booklet, on page 30, you'll see 67-2346, open legislative meetings required.
Wait a minute, Betsy, redo that one, page
Okay,
30.
Page 30 in the blue book, it specifically talks about the legislature, and as Brian said, you can't hold them to it, because they weren't created by statute, they were created by the Constitution. However, it's still there in the law, and this is the law that the legislature passed. And the legislature had discussions in the past about should they specifically exempt themselves from the open meeting law, and they decided that would be just too darn hypocritical to pass something like that when they were telling all other levels of government that they did need to apply. So you'll see that the law says, it makes reference to legislative rules. I'm the president of the Idaho Press Club, and a number of years ago, the legislative committees in both houses were holding lots and lots of closed committee meetings. And not only is there this provision in the open meeting law that says open legislative meetings required, there's a provision in the Idaho Constitution that says the legislature cannot meet in secret session at all. And so the Idaho Press Club raised money from news organizations across the state, and we filed a lawsuit against the legislature. But we did not file under this open meeting law provision. Because of that question about being created by statute, we filed that lawsuit under the Idaho Constitution. And when we got to the district court, the first question from the district judge was, why shouldn't I decide this case on the basis of 67-2346? And sadly, we had to say, because technically it doesn't apply. But we did get to the Supreme Court. We ended up losing on a 3-2 vote on the question of whether the Constitution required all legislative committees to be open. But even though we lost that case, we won. Because after that court case, both the House and Senate revamped their rules to make sure that their rules for when they can go into executive session very closely align with the rules in the Idaho Open Meeting Law. And I think that's a good thing.
Except for the caucuses still.
Yeah, except for the caucuses. And that's another story. Now it's time for a break. We'll take a 10-minute break, stretch your legs, enjoy the refreshments.